haven't had this problem in so long. Let's see if she can get back. Okay, let me check if everybody can hear me now.
All right, Barry, I'm back. Can you hear me?
Good, I can hear you. Hopefully everybody else can. I put it in discussion mode, so if you guys can mute yourself, that would be helpful. And we'll just start all over again with the agenda. Thanks.
Okay, no problem. We'll go back to the beginning. Thank you all for bearing with all of these technical difficulties. Anyway, let's start back with all the brilliant stuff that I just said that you didn't hear, but I'm going to say it all again. So we're going to talk about PAGA today. PAGA is something that's been around for a number of years, but has really come to prominence just more recently in the past few years, because I think the plaintiff bar finally figured out this really valuable tool that they had sitting there in the statute. So I'm seeing a lot of PAGA claims. I'm guessing that some of you have dealt with this already. If you have dealt with a PAGA claim, I'm really interested to hear that. So by all means, comment in the comments, because I'd like to know what type of things that you're already experiencing, if anything. So what we're going to talk about is what PAGA is, where it comes from, right? Who gets to bring these types of claims, how they bring these types of claims, and why they're bringing these types of claims, right? What sort of penalties are available to an individual who brings a PAGA lawsuit. And then really, probably even more important for all of you, we're going to talk about how you defend against these claims. We'll look at what's trending right now, the types of claims that are being brought, the kind of awards that are being awarded, and what steps you can take to protect your business from these types of lawsuits that really have become very, very common recently. So let's start with the basics and what is PAGA. So PAGA is the acronym for the Labor Code Private Attorneys General Act of 2004. So you can see right there in the title that it's been around for a while. And what PAGA does is it authorizes aggrieved employees to file lawsuits on behalf of themselves, other employees, and the state of California. So essentially what these provisions in the Labor Code do is they deputize individual plaintiffs to act as a private attorney general to enforce Labor Code provisions. So an employee, a former employee who feels that they have been aggrieved by some Labor Code violation, when they file their lawsuit, they're bringing it on behalf of themselves, their coworkers who have also been subject to the same penalty, and on behalf of the state of California. So why did this come about? This came about back in 2004 as a method to help the state. The state was arguing that due to budget shortfalls, it did not have the resources available for it to go out and enforce the existing labor laws. And so it created this method to deputize individual citizens to file lawsuits on behalf of the state and to help the state to regulate businesses that were operating unlawfully. Okay? So it's very important to remember in these types of cases that the employee is stepping into the shoes of the Labor and Workforce Development Agency, which is the department of the state that would handle these types of claims, and that the real party in interest in one of these lawsuits is really always the state. And I'm going to talk about why that's significant as we go through this discussion, but I want you to keep that in mind, that the employee is acting as a representative of the state when they bring one of these claims. And of course, the LWDA has used the significant monies that they've recovered as a result of these claims to help fund their budget. So we're going to definitely see more of it. So what type of claims can get brought under PAGA? So what type of claims can your employees bring on behalf of the state? So the statute itself lists all of the different code sections that can be brought as PAGA claims. So here's the list right out of the statute. And as you can see, it is rather exhaustive. And no, don't worry, I'm not going to go through every single one of these sections. But essentially what this looks like and what it is that pretty much every labor code section can provide for a PAGA claim. So an employee can say that they have been denied overtime, that they have been denied a meal and rest period, that their paycheck stubs haven't had all of the information that they're meant to have. You know, any type of labor code claim you can think of can be brought as a PAGA violation. Okay? And Civil Code 1199 actually expands this even further because it provides that PAGA claims can also be brought related to violations of wage orders. So not just limited to things specifically in the labor code, but also to anything that's set forth in any of the wage orders. So I want to walk you through just some of the more common code sections that are being used, that are being brought as PAGA claims. So overtime issues, you know, an employee will allege that they're not being paid overtime appropriately, nor are their coworkers. Failing to get adequate meal and rest breaks, timely meal and rest breaks. Wage statements is a big one, and I'll talk, when we get to penalties, we'll talk a little bit more about why wage statements are so significant. But what that means is, you know, the labor code sets forth a whole bunch of different things that have to be on the paycheck stub that your employee gets with their check, right? It has to include the name and address of the employer. It has to include the rate of pay, what their accrued vacation and sick, right? I mean, there's a whole laundry list of things that have to be on there. And a lot of these claims get brought over very technical type deficiencies, such as the employer's name might be on there, but not their address, right? Well, if that's what every one of your paycheck stubs looks like that goes to every one of your employees, then you've got a violation, right, for all these different employees. Minimum wage issues, employees alleging they're not being paid minimum wage, not getting tips, tips not being paid to them appropriately, not being reimbursed for expenses, commissions not being paid the way that they're set forth in commission agreements. Suitable seats is where these really started, where a lot of the popularity PAGA really started, from employees alleging that they did not have suitable seats. There are requirements in the labor code that employees have to have the ability to sit down at certain times. So that was a lot of these initial claims. Waiting time penalties, where an employee's employment ends and then the allegation is that they're not getting their final paycheck in a timely manner. Retaliation is an area that I have seen personally several times, and when we talk about remedies, I'm going to talk about why I think the retaliation claims are so popular. And then PAGA claims can also be brought for safety violations. So for things that are covered by OSHA, an employee also has the ability to bring that as a PAGA claim. So who gets to bring these types of claims? I mean, obviously we're talking about employees, but which employees are deputized in this way to stand in the shoes of the state of California and bring a lawsuit against their employer? So what the statute says is that the individual has to be an aggrieved employee, right? And all that means is that some labor code violation has to have happened to them, right? They have to have gotten a paycheck stub that didn't have their employer's address on it, or they have to not being paid their overtime. They have to have been forced to work off the clock hours, right? In some way they have to be aggrieved. It's not enough that they're aware that there's a policy in the workplace that is affecting other people. Something has to affect them personally. But they don't have to necessarily be aggrieved in the exact same way as everybody else that they're going to include as part of this PAGA claim. They just have to be aggrieved. And they only have to have at least one of the violations they allege committed against them. So what that means is that, let's say for an example, an employee brings a claim for unpaid overtime on behalf of themselves and on behalf of other employees. They could also potentially add a claim for minimum wage failures, right, on behalf of only other employees, but they themselves have not had that issue, right? They've been paid all their minimum wage, but they are aggrieved in some way. They're just not aggrieved in all the ways that they bring the claims for everybody else. Now, there is some disagreement among different courts as to whether or not those types of claims are valid. Some courts have let them slide, some haven't. So you're going to hear me say that a lot, that a lot this morning about disagreement among courts, because courts aren't really sure what to do with these PAGA claims. And there's a lot of things that are a little gray, and some of which I think we're going to get some clarity on soon, some of which we may not. They may stay gray for a little while, but this is one of those. Issues. Another one of the issues is that, the cases so far have said that the individual plaintiff has to actually have suffered some real damage in order to be able to bring these claims, not simply that they know that the policy is wrong, they've been subject to the policy, but there's been no economic damage to them. Some courts have said that they have to suffer actual damage, but that issue is currently on appeal, so that could change. One of the things that does seem to be pretty clear is that because the person bringing the claim has to be an aggrieved employee, it can't be, for example, a labor union, right? So a labor union does not have standing to recover penalties or attorney's fees under PAGA, even if their members are aggrieved employees, because the labor union itself is not an aggrieved employee. Okay, so the courts have been fairly clear that it's not an assignable right. So the only person that can bring the claim would be the employee themselves. Can an employee bring a PAGA claim on behalf of themselves only? They're not alleging that this is a practice that affects other employees in the workplace. They're only saying it's something that happened to them, right? So the answer to that is maybe. I'm not really sure. It does seem that under California law so far, cases were pretty clear that no, an employee couldn't bring a PAGA claim just on behalf of themselves. They had to be bringing it, alleging something that was affecting other employees, right? There was a case from 2015, Valdez v. Terminex, for those who are interested in case citations, that said PAGA claims cannot be brought on an individual basis. But then, just November of last year, there was another case that came out, Aviles versus Quick Pick Express, that said that if an arbitrator determines that an individual is an aggrieved employee under PAGA, then they still get to go litigate their PAGA claim in court, even though they're the only aggrieved employee. So that's another area that I think we're going to have to watch and see what happens, and whether or not individuals start bringing these claims on their own. Now, one of the things that I do want to clarify about how these claims get brought is nobody is filing lawsuits for only a PAGA claim, right? What happens is that they are one of a multitude of claims in a civil lawsuit against an employer. So an employee is going to claim the violation of the labor code individually on behalf of themselves, but they're also going to tag on the PAGA claim in addition to bringing it on behalf of themselves, right? So just to clarify, because you'll see in the remedies section that the employee is actually going to give up a whole bunch of what they recover on their PAGA claim back to the state, because remember, they're really a representative of the state. So they're also bringing the claim on behalf of themselves only. But it's just whether they can tack on that PAGA claim when the allegations they're making only relate to them and not to anybody else, okay? So procedurally, how do these claims get brought? first of all, there is a 1-year statute of limitations for an employee to start the process to bring a PAGA claim. So the first thing that they have to do is that they have to file a claim notice with the LWDA. And if you go to the LWDA's website, they have a whole, lists and lists of instructions on how that happens. Claims have to be filed online. There's forms you fill out online. And then they have to mail a certified copy of their claim to the employer. So that puts the employer on notice that this claim has been filed with the state and that the employee is intending to bring this claim on behalf of themselves, other employees, and the state of California. Okay, there's a $75 fee that the employee has to pay at the time that they submit their claim online. At that point, the LWDA has the option to investigate the violation themselves and to issue a citation. So they have 65 days in which they get to act. The state gets to act on its own. And when we're talking about a very big employer, something that looks like it's going to be a huge public policy issue, a big financial windfall for the state, those are the ones typically that they will actually say, we're going to take over and investigate this ourselves. Thank you, Deputy Plaintiff, for bringing this to our attention. We're going to take it from here. I haven't seen any of those. Usually the smaller cases that are brought, the cases that are brought against private employers, the LWDA is not going to expend their resources on. So they're going to take the notice so that they know that, hey, there might be some money coming to us on behalf, that this employee has brought this claim on our behalf, but they don't typically do very much. And usually they don't even send you a letter saying they're not going to do anything. You just don't hear from them. 65 days passes, and then the employee gets to proceed with their civil action on the PAGA claim. If the state does act, if the LWDA decides that this is one of the cases they want to get involved in, then the employee is no longer allowed to proceed with their case, right? So then it would be the state. You're not facing an investigation by the state and the employee. And so then once they file their lawsuit, they just have to give a copy of it to the state. So that's procedurally what it looks like. And the employee has 1 year from the date of whatever the allegation is to bring the claim, to file their claim notice with the LWDA. The notice that goes to the LWDA has to be fairly detailed. They have to notify the LWDA what type of violation it is. They also have to give the employer an opportunity to cure the violation, and we'll talk about curing in just a moment. But because of that, it has to be specific in the sense that it must identify exactly what the violations are that the employee is alleging, the facts and the theories supporting their claim, and it also has to say something in it about the fact that this affects coworkers also, right? Not just this happened to me. It has to be, well, this happened to me and this other group of employees also because of the company's policy. So the LWDA may choose to act on, some of the bigger wage and hour violations. The employer has an opportunity to cure in that 65 days. So let's say, for example, the claim is that the wage statements didn't include all the information they have to include. So the employer then has the ability within that time frame to go back and fix the wage statements. So the wage statement statute has a 3-year statute of limitations. So what the employer would have to do to cure would be to go back and reissue wage statements for every single employee who received a paycheck for the past 3 years. But if they did that and provided everybody with an accurate wage statement, then they have cured, and the employee does not get to proceed with their claim under PAGA because they're not aggrieved anymore. They've been made whole. Okay? Let's move on. One question that I get asked quite a bit is, at the time that a notice like this gets filed with the LWDA, is that a public record, like a lawsuit is, right? An employee files a civil claim against you, and a complaint is a public record. Is the notice with the LWDA? And the answer is yes. So anyone can go to the LWDA under the Public Records Act and request copies of any claims that have been filed against an employee, even if a lawsuit is not ultimately filed as a result of that claim. So we talked a little bit about the ability for an employer to cure. So as I said, you have 65 days from the date of the notice in which to try to cure the violation. And what that means is that you're going to make the employees whole. So if it was an overtime claim and you went back and you recalculated any overtime that was owed to any employees, you paid it to them, then the employees have now been made whole. They're no longer aggrieved, and then the PAGA claim goes away. Once it's cured, the employee does not get to continue with it. Previously, employees only had 33 days to cure. So this 65 days is actually only for newer claims that have been brought since July of last year. Now you have a little bit longer because 33 days was a very short period of time, especially you can imagine an employer with hundreds of thousands of employees. That's a lot of work to do in a very short period of time. But if the employer does try to cure the violations, or they're making any other response to the PAGA claim, they also have to file that information online with the LWDA, send a certified copy to the employee or their attorney, and pay another $75 just to say, hey, I've done everything right, or hey, I object to this claim. Whatever it is, you get to pay another fee. So what sort of penalties are available to an employee who brings a PAGA claim? Many of the statutes in the Labor Code already have penalty amounts attached to them. The statute will very clearly say that violations of this statute, are subject to penalties of whatever the amount is. But what PAGA does is it takes a claim that doesn't have any statute, and it doesn't have any statutory penalty, and it adds a statutory penalty for that claim. So if a statute is silent, then PAGA, and it's brought under a PAGA claim, then it's $100 per employee for the initial pay period, and then $200 per employee for each subsequent pay period. So for every single pay period in which an employee didn't get an accurate wage statement or didn't get paid overtime they worked, didn't get a meal break in time, then you get this penalty. If the statute that the claim is brought under already provides for remedies, then these PAGA claims get tacked on top of them, because this is a separate PAGA penalty that, remember, is being brought on behalf of the state, whereas the individual claim by the employee is just on behalf of the employees. So there is a little bit of double penalties here that can be available, right? Another example of double penalties is, let's say, meal and rest breaks, right? So there is a penalty if an employee fails to get their meal break on time, if they fail to get a rest break. There's another penalty if they didn't get paid the 1 hour penalty that they're entitled to for not getting their meal break on time, right? So you could have a missed meal period with 2 penalties attached to that. Now, these penalties clearly could add up very quickly, right, especially for a bigger employer. So the amount of the penalties is subject to court discretion. It's mandatory that penalties be awarded because the state is saying, hey, we're entitled to something, but the amount is subject to court discretion. What the courts are meant to use as their guideline in determining whether or not they're going to reduce the amount of penalties is whether they're unjust, arbitrary, or oppressive. So, for example, the double penalty on a missed meal break is going to add up very quickly, and those are the types of things where the court might say, okay, we're going to reduce those from $100 to $20 because otherwise it just gets unwieldy. The courts will also look at mitigating factors such as the employer's attempts to try and comply with the law. If this is an employer that nobody's ever complained about before, that has a clean record with the state up until this point, they'll certainly take that into consideration. So there are lots of ways that even if the employer is not able to completely cure a violation, that they can still help themselves by showing good faith and reducing some of their penalties. Okay? But in addition, there are other remedies that an employee can go after, right? So the employer is going to be liable for any damages payable to that individual employee, such as lost wages, interest on unpaid wages, things like that. The statutory penalties, the ones that are already set forth in the labor code, those are going to be payable directly to the employee. But the civil penalties, which are the PAGA violation, the PAGA penalties, those are the ones that get shared with the state, and we'll talk about how they get shared in the next slide. Another question that I have been asked is whether or not you can get rid of these PAGA penalties in bankruptcy. The answer is yes. For now, those are dischargeable penalties in bankruptcy. So how do these penalties, the ones that are being awarded on the PAGA claim, how do these get split, right? How's the state getting its money on these types of claims? So there is a 75-25 split. 75% of whatever the PAGA penalty is goes to the LWDA. So that goes directly to the state. 25% of the remaining penalty gets split amongst all of the employees that are subject to whatever this violation is. So as you can imagine, that amount can end up getting very, very small. The named plaintiff, the individual who went through the work of bringing the lawsuit, they're entitled to an enhancement, so they get a bigger cut of the 25%. It's not evenly split. Very similar to a named plaintiff in a class action would also get an enhancement for being the one to bring the lawsuit. But otherwise, the penalties, the 25% of the penalties left over get split amongst all of the employees. So, for example, there was a $8 million settlement with Uber recently, and that was the issue of the misclassification of their employees. And $8 million split amongst all of these individuals resulted in an average payout per employee of $1.08 because they had 1.6 million individuals who ended up sharing in this money. So they got $1.08 each on average. So not a huge payout, whereas, of course, the state got a huge payout because they got 75% of that amount. The reason that so many of these claims get brought, though, really is that the one person who is always going to end up making out like a bandit in these things is going to be the attorney who's representing the employee. So what PAGA says is that any employee who prevails, who recovers anything, gets all of their attorney's fees and costs. So their attorney is going to get paid, which really encourages PAGA claims for violations with no statutory attorney fees provisions. So I mentioned retaliation earlier. I've seen multiple of these cases in the last year or so. So retaliation is one of those statutory requirements that does not have an attorney's fees provision on it. So for an employee, an employer's attorney doesn't have a ton of incentive to bring one of those claims on its own because they're not going to recover their fees for bringing that claim. But if they bring it as a PAGA claim, then they're guaranteed their attorney's fees, right? And it's always a tough issue because how do you really argue retaliation on behalf of an entire class of employees where usually these are very individual fact patterns? And that's one of those things that we're going to see with the case law is whether or not the courts are going to be more willing to accept these without the employee even having to say, oh, no, but they did this to others also, right? They may just be able to bring them on behalf of themselves under PAGA, which the plaintiff's attorneys are going to be very happy for because they'll get their fees and costs. Missed meal and rest breaks is another statutory provision that in and of itself doesn't provide for attorney's fees. So anytime an employee is alleging that, it's always going to get alleged as a PAGA claim also, because that way their attorneys are going to get their fees. So this is certainly one of the things that's driving, I think, a lot of the increase in the PAGA's claims. So arbitration. I'm sure that many of you or your clients have arbitration agreements in their employment packages, right, that they give to their employees. And that's going to be a topic for a whole other seminar on really the value of arbitration provisions. But the one thing to note is that PAGA claims themselves are not subject to arbitration agreements. And the reason for that is that, remember, the employee bringing the claim is bringing it on behalf of the state. So the state never entered into an arbitration agreement with the employer, right? Only the individual employee did. So the way that these get interpreted is that the employee can take their individual claims to arbitration. The PAGA claims sit in limbo, essentially, until the arbitration proceeding is over. And then once the arbitration is over, then the employee can proceed with the PAGA claims in court. And what happens most of the time in these situations is that the cases get settled, or the arbitrator determines that the employee was not aggrieved, and that in that case, the PAGA claim would go away. Because if no money is then apportioned to the PAGA claim, then there's nothing for the state to get, and the state loses their involvement in those type of cases, right? So they just sit around and wait while the employee goes ahead to arbitration on the rest of their claims. So I'm not sure how much of an issue this is going to be for many of you, but I wanted to point it out because it's certainly a big area in the law, and that is there's this case from 2014 talks about class action waiver provisions in arbitration agreements. So if you have an arbitration agreement with your employees, you can put language in there that says the employee waives their right to participate in a class action lawsuit against you as the employer, right? So those types of waiver provisions have been upheld. However, what the courts are now saying is that you cannot also put something in your arbitration agreement language that says that the employees also waive their right to participate in a PAGA claim. And the reason for that is, again, because the PAGA claim is with the state, right? Even though the employee is the one who's bringing it, they're bringing it on behalf of the state, and the state did not agree to your arbitration provision. So the state can't be bound to either go to arbitration or to waive their right to bring these types of cases. So there are currently 2 cases that are pending that challenge the validity of even the class action waivers. So it'll be interesting to see what happens with those. We should know more within the next few months. I'm a little concerned about how that may affect PAGA claims going forward. I think if the class action remedy is really not available anymore, I think the value of PAGA claims is going to go up, and we're going to see a lot more of them. They're going to be much harder to get rid of, too. So we have to see what the courts decide to do in that, but I don't see PAGA going away anytime soon, and I certainly think it's going to get more powerful. Okay, and then a follow-up case in 2014 says not only can you not put a PAGA waiver in an arbitration agreement, it just clarified that you can't put it anywhere. There's no other place that you can put a PAGA waiver that's going to be enforceable because the state's not going to get the chance to sign that. So there's no way to get out of these. So we talked just a little bit about settlement. So let me give you just a little more detail about how this works when you're trying to settle a case that has PAGA claims. Because, you know, what happens to the PAGA claims when the employee settles their individual claims, right? So an individual, let's say for an example, the individual claims go to arbitration. The PAGA claims get put on hold while that arbitration is ongoing. And during the arbitration, the employee settles all their individual claims for $20,000 and plus attorney's fees. And as part of that settlement, they agree to dismiss all of their individual claims and all that's left then would be the PAGA claim. Well, so in this case from the very end of last year, the California court said that once an employee settles their individual claims, they're no longer an aggrieved employee, and now they don't have standing to bring that PAGA claim. So their PAGA claim that that's sitting on hold goes away, right? Although this case, a petition for review by the Supreme Court was filed on February 6th of this year. So this is another one of those issues that could change. If it's overturned, then employers will have to make sure that any settlements include some resolution of the PAGA claim, right? And what happens when a PAGA claim is resolved, then the courts have to get involved, and I'll talk through that in just one moment. But in the situation right now, the way we have it, when the individual employee settles their claim, then the state still has the ability to move forward on behalf of other employees. So another employee could jump into that individual's shoes and proceed with a PAGA claim, but that specific individual is no longer aggrieved and they can't do that. What happens when you're litigating one of these cases and you do settle the PAGA claims themselves? Well, remember, the employee is settling on behalf of the state, so the state has to know what happened to this claim that they're going to get some money on, right? So a copy of the settlement has to go to the LWDA, and the court is required to review and approve the settlement. And the grounds that the court is approving it on is whether or not it is fair, adequate, and reasonable. So any time that any monies are going to be apportioned towards the PAGA claim, you have to get in front of the court. Now, I haven't had this experience yet, but I know of several other local attorneys who have, where the court has not approved the settlement as written and is requiring the employer to then go back and jump through additional hoops. They want to see calculations on different employees, different subsets of employees, and what they may or may not have been entitled to determine if it really is fair for them. So there can be additional costs incurred, even though you think you've settled this. The plaintiff is willing to reach a resolution with you, but the court might say, we want you to do a little more work, and there's always that risk anytime any money is apportioned towards the PAGA claim. And once it's finalized, once the court makes its decision, then the LWDA has to be notified. They do not also have to jump in and approve it. They simply just have to know, because remember, they're going to get 75% of whatever got apportioned for that PAGA claim. And the courts will definitely look at the strengths of the individual's claim when they try to make the determination about whether or not the settlement is reasonable. So anytime you're resolving one of these cases, you always have to keep in mind that the court's got to rubber stamp it before you get to actually move on and have it be finished. So you have to make sure that it looks like something that the court is going to accept. What about release agreements? At the end of a lawsuit, and unfortunately, I'm assuming that most of you have been involved in some sort of employee claim, right? It always is going to end with some sort of release agreement where the employee is going to get whatever their settlement is in exchange for releasing their right to bring any other claims against the employer, right? You're shutting off their ability to then go back to court and say, well, there was also this other thing that happened to me while I was there. I want to now bring another lawsuit, right? You don't want that revolving door of claims from an employee, so there's always going to be a release agreement signed as part of any settlement. But how do these types of release agreements bind all the other employees that are part of this PAGA claim, right? Because unlike a class action, and I'll compare the two in just a moment, but unlike a class action, all the other employees don't get any notice of this PAGA claim. But for now, the courts are willing to recognize that all of those other aggrieved employees, their rights to bring the same type of lawsuit are also released when an agreement is signed on a PAGA claim, because the individual is representing the state, which is really who the party in interest is. So once the state is released, then the claim goes away. Now, it's only as to those specific claims that that individual brings, so it doesn't mean that a different employee can't say, okay, well, my friend brought this claim on meal and rest breaks, but I'm going to now bring a PAGA claim on overtime issues. That they could certainly do. It doesn't release them of the ability to bring any PAGA claims, but it does release them of the ability to bring anything related to what was already pled. Now, because there's all of these employees who are subject to this release agreement who had no knowledge or involvement in the case, presumably, the PAGA statutes say that you cannot put a confidentiality provision into a settlement agreement that contains any sort of apportionment for PAGA, because that agreement has to be filed with the LWDA, where it then is going to become public notice, and it has to go to the court, where it's also going to become public notice. So you can't have a confidentiality agreement. So if you're settling individual claims with an employee and PAGA claims, then generally what I do is have two separate release agreements. One that we include confidentiality for the individual claims brought by the employee, and one where we don't for any apportionment for PAGA claims. So I've mentioned a couple of times the comparison between PAGA and class actions. So a class action lawsuit is a claim that's brought on behalf of a group of employees, right? It's not also brought on behalf of the state. It's just brought on behalf of the employees. So that's the big difference. But the employees that are not part of the lawsuit have very different rights in a class action and a PAGA claim. So class action, the individual plaintiff who's bringing the lawsuit represents themselves and all of the other employees, whereas in a PAGA claim, they represent themselves, the other employees, and the state, right? The unnamed employees in a class action then get those notices where they get to say, hey, I don't want to be part of this class action settlement because sometime in the future I might want to bring my own lawsuit, right? We've all got those little postcards from the Netflix class action, or other retailers who go through class actions where you get a little postcard saying, hey, you've been included. You can opt out if you want. That doesn't happen in a PAGA claim. The other employees don't ever get notice that the lawsuit is even going on. They are bound by the settlement agreement or the judgment, and they're prohibited from bringing their own claims because this issue has now been resolved. So not nearly as much involvement for the other employees because, again, really, this is all about the state. Okay? It doesn't, in a PAGA claim, those other employees are not parties to the lawsuit. They're not even clients of the attorney that's representing the named plaintiff. So that means that that attorney and that individual plaintiff have no express fiduciary obligations to the rest of the employees. They don't have to take them into consideration when they reach a resolution. So there are no due process rights for the absent employees in a PAGA claim, which is very different from a class action. What's not clear is whether or not any of those employees who don't participate are then entitled to the right to appear at the hearing where the settlement is being approved by the court and to voice any objection to the settlement. You don't have to notify them of it, but if they're aware of it, do they then have standing to stand in front of the court and say, hey, I object to the settlement? I don't know the answer to that. It's really not clear. I'm not aware of any situations where it's happened, but I presume that if an employee were to show up, the court's going to let them talk. Whether or not they're going to give any weight to what they say is probably going to vary on a case-by-case basis. But if a judgment is issued in a PAGA lawsuit, then who gets to appeal? Well, there's now two groups that could appeal the decision, which one is the state could appeal it because the LWDA doesn't get to approve the settlement, and also any of the employees that were subject to that judgment would also have the ability to appeal it. Okay, so a lot of complicated procedural issues, but they're important to understand as an employee who could face one of these types of lawsuits, because you need to know what the playing field is that you're walking into, right? And what it's going to, once you resolve this case, what doors does it really close, and what doors are still open a little bit, and what doors are still open a lot, right? So that's why I wanted to walk you through a little bit more of this procedural stuff. So let's talk about what's actually happening right now. Well, there's certainly been an increase in PAGA claims over the past several years. So the number of, what you see on the slide is the number of notices that were filed with the LWDA by employees in each of these years. So 2010 to 11, there were 4,430, and the LWDA itself collected penalties of $4.5 million. You see that for their next fiscal year, it goes up from 4,400 to just over 5,000 claims. Also, the amount of penalties goes up. Next year, again, the number of notices filed jumps up to just over 6,000. Penalties went down a little bit, but don't worry, they're going to go right back up. 13 to 14, we're at over 7,000. And then the last numbers that I could find that have been published so far were 2014 to 15. The LWDA took in 6,307 notices from aggrieved employees and collected $8.4 million in penalties. So even though a slightly lower number of notices filed, a significantly higher number of penalties collected, which suggests that they're just being that much more aggressive on how they're treating these types of claims. And that's very clear also. The LWDA has said that it uses the settlement funds that come in to hire additional enforcement personnel. So the LWDA has made it very clear that they plan to continue to pursue PAGA claims, and they're bringing on more folks to try and go after employers on their behalf. So as you can imagine, there's been quite a bit of backlash to these types of cases from groups that are working to protect employers. I know it never feels that there are any such groups in California, but there are some, and they're really trying very hard. There's a local organization, California Business and Industrial Alliance, that I know very little about other than what I've read about on social media and from their website. But they're a trade organization which has been formed to educate California's employers about, about PAGA and about the types of judgments that are coming out. If you're interested in them, their website is pagascam.com, and you can get some more information from them. There's also been 3 separate reform bills have been introduced to the Assembly or the Senate in California to try and pull back a little bit of the power of these PAGA claims. So we'll see what happens there. The LWDA itself has said that they've introduced changes to try and improve transparency and data collection. I haven't seen any of those changes go into effect yet, but we'll see if that's going to happen. All right,
Laura?
so I did save the best for last. Yeah.
Laura, if I could just go back one slide, if I could just add something about Cambia. The Cambia was started by 2 employers that were hit with PAGA lawsuits. One was Timely Industries in Pacoima that had to settle for $1.2 million plus attorney's fees, and also Town and Country Rentals. I don't know what their settlement was, but the owners of both companies, along with members of the business community in the San Fernando Valley, has started this organization to try to lobby for changes in the law.
Right, that's absolutely correct. And that's why I said, check out their website if you're interested. I mean, they're definitely fighting the fight right now on trying to get rid of this, or at least trying to curtail it a little bit. So what are some specific steps that you as an employer or as an advocate for employers can take to try and reduce your liability in the face of PAGA claims. I wish I could tell you that there was some magic thing that you could do where you would then be guaranteed you'd never face one of these, but you know, employees are always going to have the ability to bring frivolous lawsuits, and so we're always going to have the possibility of being faced with one of these. So let's make sure that we're doing the best we can to protect ourselves if and when they happen. So if you remember back to the penalty slide, I said that the penalties that PAGA imposes are on a per pay period basis. So really, this is a great example of the no good deed goes unpunished, right? I have many clients who have been paying their employees for years on a weekly basis because their employees like getting their paychecks that frequently as opposed to having to wait 2 weeks. But all that does is now that employer has 52 pay periods, right? So it increases the number of pay periods, which can double the size of the penalties. So what I recommend to all employers at this point is that you're much better doing semi-monthly pay periods as opposed to biweekly pay periods, which are really the two most common options, right? Because biweekly is going to be every 2 weeks, whereas semi-monthly is going to be twice a month, like the 15th and the last day of the month, something like that. So with semi-monthly, you're going to have less pay periods than you are with a biweekly pay schedule. Now, that doesn't mean that you couldn't make a compelling argument to a court to reduce a penalty if, say, you're paying weekly or you're paying biweekly to say, well, look, this is really unfair because it's the same amount of money going to the same people. We're just giving it to them more often because we're trying to be helpful for them. Yes, that could very well be a compelling argument, but I wouldn't bank on it. I have no guarantees that you'll get your penalties reduced on that alone. So the safest way to handle that would be to have as few pay periods as possible, which means you're going to pay semi-monthly. All right. If you get one of these LWDA notices, remember the employee who goes and files it online with the LWDA is required to mail a certified copy to the employer, putting them on notice that they filed with the LWDA. You have to take these notices very, very seriously. The first lawsuit that I handled on one of these, the employer got it, read the notice, said, this is ridiculous, I clearly didn't do any of this stuff, and threw it in a drawer, and I didn't know about it until after the lawsuit was even filed. Whereas we could have taken advantage of the time that is allotted to try to cure the violations and prove to the LWDA that there was no violations, right, that the employees were not aggrieved anymore. So use that time, take advantage of the opportunities to cure. Not all claims are curable, right? If an employee is alleging that they were terminated in retaliation for reporting some sort of, whistleblowing, then how are you going to cure that absent rehiring them, which I'm sure don't want to do, especially when that's not really the reason you terminated them. So some things are not going to be curable, but things like the pay stubs, that's definitely curable. Or if you discover that your overtime policy has not been implemented correctly, do the calculations, make everybody whole, and then you've cured it. You do have to look at how many employees are going to be affected by this. And remember, it's not just current employees, it's also going to be former employees. So you really want to conduct an audit when you get these types of notices. You also want to periodically, as an employer, be auditing your wage and hour policies and your safety policies. Having policies in place is not always enough. You have to make sure that they're also being followed. Do your individual managers understand when they have to make sure your employees get meal breaks? Do your individual managers understand that the employees working under them are entitled to a rest break, morning and afternoon, right? You want to make sure that that all of your policies not only exist, but that they're being followed. And if you get one of these notices, what I highly recommend is that you expand your audit beyond just the direct allegation in the notice, because that could be just the tip of the iceberg, right? That's just the thing that the employee is aware of right now. But as the lawsuit progresses and they're entitled to discovery and additional records, their attorney may discover a whole bunch of other violations that the employee wasn't even aware of yet, and that's going to expand your liability. So doing regular audits of your wage and hour and your safety policies is crucial for every employer, even without PAGA. You want to make sure that employees are not subject to any retaliatory behavior as a result of bringing these types of claims or participating in these types of claims, because I've seen several secondary lawsuits that have arisen because an employee is alleging they were retaliated against as a result of participating in this. So this goes for the employee that brings the notice and any of the employees potentially impacted by the allegations in the notice. So be very, very careful with that. And finally, make sure that if you have an arbitration agreement that you are requiring employees to sign, make sure that it's updated, right? You can have a class action waiver in it right now. You cannot have a PAGA waiver. So make sure that your arbitration agreements are in compliance with the law. That's it. Hopefully I didn't scare you all too badly, but I wanted to make sure that you really understood what PAGA is, what these lawsuits look like, and what you can do to try and reduce your likelihood of getting faced with one. If any of you have any questions going forward, my contact information is right here on the first slide, and I'm, of course, happy to answer any questions or help guide you through this process.
Let me step in here and say thank you, Laura, for an excellent webinar. Because of the technical difficulties, we went over 10 minutes, and I appreciate everybody staying on the line. We missed my intro of Laura because that wasn't done when we were recording and everything was good. So let me just say that Laura is an attorney with Nevers, Palazzo, Packard, Wildmuth, and Winter, and she decided to go to law school to help businesses and business owners and managers overcome the challenges of operating businesses in California. She'd been with the Conejo Valley Chamber of Commerce, looked at a lot of businesses, worked with a lot of businesses, and decided to go to law school. Went to USC and graduated, and for 3 years was a recipient of a special scholarship because of her work at law school. So I wanted to thank Laura for presenting today. If anybody has a question they want to type in right now, we'll wait a couple seconds here. Next month, I believe our webinar will be on the new Dynamex ruling by the California Supreme Court about independent contractors. We haven't finalized that yet, but chances are it'll be the second Wednesday in June. And if you haven't heard about this case, there is now an ABC determination about whether someone's an independent contractor or an employee. And I went to a breakfast this morning, and 4 business owners were talking about this ruling. So I think that might be the next webinar. Anybody have any questions? Well, seeing none and seeing nobody typing, thank you again. We recorded the webinar. It will go out in the next couple days to you with also a PDF of the PowerPoint. If you have any questions, as Laura said, feel free to give her a call, and hopefully we'll see you all next month. Thanks a lot.
Thank you. Thank you so much, Barry.